Small business IP protections. Learn why protecting intellectual property matters and practical ways small businesses can safeguard their intellectual property. What is intellectual property and how do I, as a small business, protect it? Businesses of all shapes and sizes create intellectual property when they develop a proprietary process, product, logo, or other original work. For instance, a small bakery crafting a gluten-free bread recipe owns that recipe as a trade secret, and the unique name is a trademarked product. If an employee sells the recipe to competitors, it violates the bakery's intellectual property rights. What can the bakery do now to ensure no further damage? What should the bakery have completed sooner to avoid infringement? These are all examples of intellectual property and how to protect that. We're going to go over three cases. Case one is WinPact. This case shows how a former NFL player's startup used intellectual property to turn car seat padding technology into sports protective gear. This emphasizes the need to secure IP rights early to protect innovation and gain collaboration. Case two is Greenleaf Organics. They created a unique formula and gained market success but lacked IP protection. This allowed a rival to copy it and confuse consumers, which harmed sales and brand identity. This shows the risk small businesses face without proper IP safeguards. Case 3 is Blue Spike. A company labeled a patent troll filed broad patents to sue startups and small and medium-sized enterprises, often causing prolonged legal battles. The misuse of the patent system mainly harms small businesses that cannot afford lengthy fights. To begin exploring intellectual property protections, we look at WinPact, a small business success story. Headquartered in Leesburg, Virginia, WinPact's main product is Crash Cloud, a material built into helmets and seats to absorb impact energy. Founded by former NFL player Sean Springs, the company invested early in patents and trademarks to protect its innovation. After retiring, Springs focused on preventing head injuries in football, and his IP strategy helped WinPact grow into a trusted brand. Sean Springs was inspired by a safety-first car seat pad to rethink football injuries as multiple car crashes. With permission from the parent company Dorrell, he expanded on the safety-first patented technology. In 2011, Springs trademarked his company WinPact and patented his helmet padding innovation, which was later branded as Crash Cloud. By 2014, he built a team of engineers and scientists from Virginia Tech and North Carolina State to refine the technology, securing additional patents in 2018. Crash Cloud proved effective across sports and military applications, which led to collaborations with Emo Shield, Hummingbird, and the U.S. Army. Springs followed IP protections carefully and credited his inspirations and collaborators, which transformed WinPact from a startup into a thriving ethical business. Greenleaf Organics was a fast-growing, small-sized enterprise specializing in sustainable skincare products that developed a unique botanical formula which set them apart from their competitors. Protecting intellectual property means preventing competitors from copying ideas and supports safe market expansion. When small businesses fail to act, they risk serious losses. Greenleaf Organics illustrates this. After creating a unique formula and gaining strong sales, they neglected IP protections. Their IP was stolen from a rival company, and they then had to reverse and go back to stage one. They had to register their trademark so that nobody else could use it. They had to file a patent so that their unique formula was protected and unable to be used by anyone else. They had to file a cease and desist against the competitive company to ensure that all production would stop immediately. And then they had to go back and reinforce their market to make sure that everyone knew that Greenleaf Organics was the original product and that they should buy from them rather than any other company on the market. After they took all of these steps from the start, their stuff was stolen. They had to go back and reverse the steps. And then 6 months after that, sales rebounded as customers noticed the authenticity of their brand. Then investors took notice and they secured a new round of investors, which facilitated further growth. And then they had greater brand authority and they positioned themselves as an industry leader, which fostered brand trust. Not only should small businesses be knowledgeable in their own intellectual property protections, but also in preventing use of others' intellectual property. Blue Spike is a Texas-based established company, that became infamous for suing dozens of startups over alleged patent violations. They targeted startups acting as a patent troll through filing overly broad patents to extract settlements. Some disputes ended quietly, but others dragged on, which drained small businesses of time, money, and resources. This bar chart highlights the stark differences of cost between litigation, settlement, and preventative legal action. Litigation is by far the most expensive path, with costs piling up from attorney fees, filing fees, discovery, and court expenses. For small and medium-sized enterprises, the average litigation cost is around 1.5 million per case. And in contrast, preventative measures average just 30,000. For a small business, this difference can mean survival or collapse. And this is just a summary of the different companies and cases that we studied and how they all have such great differences between how they handled intellectual property protections, and that really defined them as a company. This flowchart illustrates three paths small businesses can take with intellectual property. First, they can protect their intellectual property, as Winpact did, turning proactive protection into growth and expansion. Second, they can neglect IP, like Greenleaf Organics, which saw early success but lost ground to copycats before having to reinforce protections. And lastly, they can abuse intellectual property, as Blue Spike did, exploiting laws meant to protect innovators and using them instead to harm startups. These examples show how IP strategy can drive success, expose vulnerabilities, or be misused to stifle competition. In this Venn diagram, we see three different arguments for and against intellectual properties for small businesses, how they can help and harm them. On the left side, we see how safeguard innovations, market expansion, asset creation, and legal remedies all can help a small business through intellectual property. These offer small businesses powerful advantages. Patents, trademarks, and copyrights safeguard innovation by preventing competitors from copying unique ideas, formulas, or branding. They also support market expansion, allowing businesses to enter new spaces with confidence, while creating intangible assets that boost company value and attract investors. IP rights even provide enforceable remedies in court, deterring infringement and offering damages when violations occur. However, these protections come with challenges. Filing patents and trademarks can be incredibly expensive, and enforcing them through litigation is both costly and time-consuming, as seen in cases like Blue Spike's patent trolling. Navigating intellectual property law often requires specialized attorneys, and in fast-moving industries, patents may take so long to process that competitors have already moved on. The best course of action, in my opinion, is that small businesses do not need massive intellectual property portfolios. They need smart, targeted protection. They should protect what matters most: brand, innovation, and secret formulas. They need to prevent problems before they arise through using patent insurance and contracts. They should treat intellectual property as a growth tool that keeps competitors out and brings investors in. Trademarking your business name and registering copyrights for original content are affordable, quick, and straightforward steps to protect a new business. These protections safeguard brand identity and creative work. Intellectual property rights are available to all businesses. Use them to your advantage. Document efforts to keep proprietary information secret, and your trade secrets will be legally protected. File patents selectively. Patents are powerful but expensive, so focus only on innovations that provide a true competitive edge to prove to be innovative and marketable. Conduct freedom to operate searches to avoid infringing on existing patents. These are free and can prevent costly disputes. Finally, build intellectual property into your business plan. Treat intellectual property not just as legal paperwork, but as a growth tool. It protects what makes your business unique, builds investor confidence, and opens doors to new markets.